Hey guys, Mahir Nisar here from the Nisar Law Group. So I know this is a very different time than most times, right? We're all experiencing the challenging aspects of how the coronavirus is impacting our life and our livelihood. Now, when it comes to situations when you are working from home, or let's say, for instance, you're working within an essential business and you are still required to go to work and they still have the ability to do so, just keep in mind one thing. The EEOC has provided some form of guidance, which is in essence trying to give information on how they would view certain Americans for Disability Act related aspects in this scenario. Now, what that mean by that is that how are they going to look at scenarios in which the employer is going to be wanting to take your temperature? The employer is going to want to have medical documentation from you, whether you're fit or not, and that you're clear from COVID-19. Whether you are showing any kind of symptoms or influenza or flu-like symptoms, and how the employer can treat you in that situation, and what laws under the ADA would protect you versus what deference would the EEOC provide to the employers. That is a question that a lot of people and attorneys are concerned with, because under the circumstances, certainly we're in a national crisis, and in that situation, the employers are essentially trying to avoid the community spread and to try to protect the overall workforce. And so what it seems to me through the EEOC that they have given employers some form of deference to make sure that their overall workforce is going to be protected and that any community spread is limited and that they can conduct certain forms of rather unconventional types of behavior or testing to try to determine whether there's any potential risk as a means. And that would not be considered discrimination on the basis of one's perceived disability. Now, there are arguments. There are going to be scenarios in which perhaps an employer may couple that with, let's say, national origin. If you are Asian, of somebody of an Asian origin, and they are unfairly targeting you because of where you're from, then that's a clear violation of Title VII's national origin and New York State and city law with respect to national origin discrimination. And that's something that unfortunately has been happening within the Asian American community, not only in terms of discrimination on the basis of COVID-19, but just on the very mere basis that people have been experiencing hate and discrimination and unfair targeting within the workplace and outside of the workplace due to the coronavirus and Donald Trump's comments about it being a Chinese virus, when that is completely far from the truth, an unfair statement to make in these given times. So just keep that in mind, that, listen, the EEOC has given guidelines that have somewhat expanded an employer's ability to make sure that their work environment is free from any symptoms, but it's not an excuse to engage in unfair targeting and unlawful harassment and unlawful discrimination solely on the basis of one's national origin or even a perceived disability. But listen, every situation is unique. There may be scenarios in which, based upon the conversation you have with an attorney, that an attorney may be able to see a perceived disability discrimination claim, or one that is potentially can be pursued through the New York State or city laws and the human rights laws. So look into it. If you are experiencing any form of discrimination at this time, whether you're working from home or you are an essential worker working within your business that is named as essential, feel free to reach out to an attorney to see what your rights are. And as always, direct message us. We'll be happy to help you in any way we can. Take care, guys.